Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Alex Barthet, a Florida construction lien law expert. Today's webinar topic is chargebacks and bad checks, how to deal with them. So without further ado, I'd like to introduce the fabulous and wonderful Alex Barthet.
Thanks, Jesse. My name is Alex Barthet. I am a board certified construction lawyer here in Florida. And today we're going to talk about chargebacks and bad checks and how to deal with them so you can still get paid. So on your screen, you should have the GoToWebinar chat box. We will answer any questions that you have. You can include them in the question section of the GoToWebinar chat box. Please do not include the names of any company or people in your questions. All right, so what are we going to talk about? First, we're going to talk about bad checks. We're going to talk about the civil and criminal penalties for passing a bad check. We'll talk about credit card chargeback procedures, what to do, what not to do. And then I'll give you some tips at the end to how to minimize your risk associated with both bad checks and chargebacks. And of course, we will answer any questions you have at the end. So let's talk about the criminal and civil penalties associated with bad checks. So let's start with an understanding of what a check is. A check is merely a promise to pay. It's an IOU. So when someone gives you cash, green dollar bills, that's real money that you can use immediately. A check is just a promise to pay that has to run through someone's bank. And the bank is the one that's going to fund it. It's, trust me, I have money. Here's a little piece of paper that says that if you take it to my bank, they will give you the money that I have. That's what a check is. So the most common bad checks that we see are designated as either NSF, which is non-sufficient funds, not enough money in the account when the check is presented. The account is not found, meaning that it was a fake check or the check was issued and then the account was closed, or a stop payment. Someone has issued you a check and then has gone to the bank and said, please do not honor this check if it is ever presented to you. So those are the three major classifications of bad checks. Understand that a check can be dishonored typically up to 30 days, but sometimes even after 30 days after it has been presented. Here's a very important point that people don't understand. The fact that your bank says the funds are available is not the same thing as the check having cleared. Let me say that again. It's very important. The fact that your bank has given you access to those funds does not mean that the check has cleared. So let me explain what this means, because it's a very important distinction. If you have $100,000 in your bank account and you deposit a $10,000 check, your bank may make that check available immediately or within days. And the reason they do that is not because the $10,000 check is good, it's because they know that if the $10,000 check is dishonored, they have enough money in your account to protect themselves. They, the bank, your bank has enough money to protect themselves. So let's assume that you have $100,000 in your bank. The $10,000 check is deposited. It's available to you. So now your balance is on paper $110,000. And then on day 29, they put a stop payment on the check. Your bank is going to now deduct the $10,000 from your account. But because you have $100,000 in the account, they are secure. They feel okay. So you don't know that a check is cleared or won't be dishonored just because the funds are made available to you by your bank. Now, there are penalties for passing bad checks. Those penalties are both civil, meaning you could sue someone in court and have them pay you money, or criminal. Someone could get arrested or go to jail. So let's talk about each of those penalties and how they are implemented. So let's start with a criminal. A bad check of $150 or more in the state of Florida is a felony versus a misdemeanor. So you don't want to sign your bond or lien, or you don't want to sign away your bond rights or lien rights if you are concerned that a check may be good or bad, right? So if you're not certain that the check is going to clear, you don't want to give an unconditional lien or bond release. You especially don't want to record a satisfaction of lien before the funds have cleared, right? So if you've recorded a lien and someone says, okay, please satisfy the lien, here's a check, you want to make sure that those funds are clear before you satisfy the lien. So we have a tool, it's called the Make Me Conditional Stamp. You can get it completely for free at makemeconditionalstamp.com. And it is a stamp that you can put right on your releases, and it will add the conditional language. Now, if you use SunRay to do your releases, SunRay has conditional releases built into their system. But if you're still using paper releases, or you have to sign a release that someone else gives you, if you go to makemeconditionalstamp.com, put in your information, we will send you this stamp for free, and then you can stamp to your heart's content so that every time you give a release, you know that it's conditional. There's a little blank in the stamp, and that's where you're going to put the value of the check you're expecting. So if you're expecting a $10,000 check, you're going to stamp the release, and in the blank, you're going to write $10,000. Okay, so a few other things to keep in mind. Don't believe that holding a slip of paper, the check, is the same as having the money. Obviously, as I told you, it's just a promise to pay. So if someone gives you a check and you're just holding it, you don't have money. You have the promise that hopefully there's money in that account in the future. Don't accept post-dated checks. That is a check that I give you today, but the date on the check is next week. That is a post-dated check. If you accept a post-dated check, the maker of the check will not be criminally prosecuted, right? They've told you in advance that I am presenting a check to you today that you cannot deposit. Don't agree to hold the check. Hey, here's a $10,000 check, but don't deposit it. Let me call you next week and let you know when you can deposit it. If you accept a check with that condition, the maker will not be criminally prosecuted because you've agreed upon the presentment of the check that there are not sufficient funds in the account, and that's why they're telling you to hold the check. So when you accept a check for criminal penalties to apply, you must do the following. If you're accepting a check in person, you have to obtain the following information from the check presenter and write it on the check itself. Now, I've been doing this a long time. No one ever does this, but this is what the law requires. And if you want someone to be criminally prosecuted and you take this to the police or to a district attorney, they're going to expect to see this because they want to make sure that you've complied with all of the requirements. So you have to write their full name, their home address and phone number, their place of employment, their sex, date of birth, height, and driver's license number. All of that has to be written on the check. Again, I know no one does this, but to be subject to criminal penalties, this is what the police want to see on the check. Now, if you're accepting a check in the mail, the recipient of the check must have an original contract, order, purchase order, or some other request of service which the check is supposed to pay, and that agreement has to have the signature of the person signing the check. If the check is returned and marked by the bank as NSF, not sufficient funds, or the account is closed, then you must send the following written notice by regular and certified mail. Technically, it's just certified, but we always recommend that it go regular and certified. You have to send the following notice. So for all of those of you listening to this presentation, know that SunRay is going to send you a copy of the presentation. If you'd like copies of these documents, you can send me an email, alex@barthet.com. I'm happy to email you these forms, no problem. But this is the criminal bad check letter. And it in essence says, hey, you've presented a check that's no good. There are penalties associated with it if you don't make good on this check promptly. This is a required document that has to be sent before criminal penalties associated with the check will be imposed. So after 15 days, if that check is not paid, you can then report the matter to your local state attorney's office. If you Google, your city and state attorney's office, you will find your local state attorney. All of them have a bad check or worthless check division. This is obviously a significant enough problem that they have an entire division associated with bad checks. So they have a process in most offices on how to report bad checks. And then it's up to them on whether or not they want to prosecute someone for passing a bad check. However, keep the following in mind. For civil penalties, right? So that means criminal penalties, meaning someone could get arrested or go to jail. Civil penalties are you can sue someone and get them to pay you money. So for civil penalties to apply, you don't need to do all of that, okay? Here's what you have to do. They apply to NSF checks, closed accounts, and stop payments on checks that have been presented to you. The only thing you really have to do is send what's called the statutory demand letter by certified mail. Again, we recommend that you send it via regular and certified. And if you do this and they don't make good on the check in 30 days, you are entitled to the following: the amount of the check that was no good, plus 3 times the amount of the check that was no good. So we're up to 4 times the amount of the check, plus your legal fees and costs in having to sue them and recover your money. So that's what you would be entitled to if someone passes you a bad check, either NSF, account closed, or stop payment, if you send them this demand letter. So again, it's a pretty straightforward letter. If you want a copy of the letter, I'm happy to send it to you. Just send me an email with your request, alex@barthet.com. I'll send you the form letter. And the form letter has to say, you've issued this check drawn on this bank. It hasn't been paid. You need to pay me in 30 days or I'm going to sue you for treble damages. But again, there's a specific statutory form that you need to follow. And once you send that check, then you wait 30 days. And if the check is still not paid, you can then file a lawsuit, again, for the face amount of the check that wasn't honored, plus 3 times the amount of the check, that's the treble damages, plus your legal fees and costs. But know that if someone is giving you a bad check, it is highly unlikely that they're going to have enough money to pay you even the check amount, let alone 4 times the check amount. That being said, I would say in our office at any given time, a few times a year, several times a year, we're sending out bad check demands, and a few times a year, we're suing people for issuing bad checks. So most of our clients still want to enforce their rights and get a judgment because, again, the fact that someone gives you a bad check today and they may not be able to pay today doesn't mean that, for the life of the judgment that you get against them, which is 10 years, that they may be able to pay you in that period of time. Okay, so that is bad checks, civil and criminal penalties. Let's talk about credit card chargebacks. First, how does it work? Let's talk about how it works. So the consumer needs to submit a complaint to the issuing bank. They usually have between 60 and 120 days to issue that complaint. Then the issuing bank verifies whether the dispute is valid. Did it meet the minimum threshold? Usually it will. And if so, then the consumer is immediately refunded that money. So the money goes back into their account, and the cardholder's bank initiates a chargeback process to the merchant bank. That is your bank, right? So if you're the merchant, the chargeback goes from the consumer's cardholder's bank to your bank. So now your merchant bank that processes your credit card transactions verifies that the request is valid, and again, it meets its own minimum threshold, and you are then notified that a chargeback process is underway. So one of two things can happen. One, if the chargeback is deemed invalid by the merchant bank, you don't have to do anything. The processor will contact the other bank and inform them of their findings, and the whole process is over. So other than you being made aware that the chargeback happened, you don't have to do anything and you win. This is very rare. Most of the time, it's option number two. The chargeback is deemed valid. Again, not that you're wrong, it's just that they've met the minimum criteria by both the issuing bank and the merchant bank. And then now the merchant bank, your bank, is going to ask you for documentation to support your part of the chargeback dispute. So now it's up to you to provide sufficient evidence that the chargeback is improper. If you do, then you will win. The chargeback will be canceled. The money will be put back into your account, and then that's fine. But if not, the chargeback remains held against you. The funds are removed from your account, and you may be charged additional fees. That's effectively meaning that the consumer has won. Now, the way that you can win a chargeback is that you have to make sure you understand what your merchant bank and the processing networks expect you to do with each transaction. Generally, they look like this. One, you have to obtain proper verification from your customer. You have to make sure that they sign their receipt and that the name of your business is legible on their bill. You have to verify that the card is not expired, and you have to verify that the card holder is actually who they say they are by both verifying the signature on the back of the card and checking for identification. Again, if you want to be extra careful, you want to keep a copy of that information so that if a chargeback happens, you can prove that you did all of these things. You also need to meet the necessary minimum security standards, which are things like chip readers. You have to have evidence that you're capturing your customer signature. This is obviously all done digitally now. And you cannot accept signatures. Sorry, you cannot accept credit cards with no signatures on the back. If you are presented with a credit card that doesn't have a signature on the back, you are supposed to reject it. Here's probably the most important part. You need to have strong written terms and conditions of sale that the customer must sign, and to the extent that you can show that this transaction is valid because your terms and conditions control the outcome of this dispute, then you will significantly increase the likelihood that you're going to win. So let me give you an example. If you have terms and conditions that say all sales are final, no returns, all merchandise sold as is, and then someone charges an item on the card, and then they do a chargeback, when you present to your evidence that they signed this agreement, they understood that all sales are final, you have a much higher likelihood of prevailing than if you had no such terms and conditions signed by the consumer. And I say consumer, but this is even any business customer that may be purchasing on your credit cards. So having strong written terms and conditions is very important to winning chargebacks. So let's talk about best practices. When in doubt, get a wire. A wire transfer is instantaneous transfer of funds, instantaneous meaning within a day, a business day of funds. So if you wire me money and that money hits my account and I can confirm it and I can see it on my account, unlike a check, which is just a promise to pay that could be dishonored, a wire transfer, that money is mine. It's in my account. I get to keep it. Always protect your lien and bond rights. Your lien and bond rights are the single best way for you to secure your right to be paid, no matter what. Never, ever, ever sign a lien or bond release if you are concerned that the check is not going to clear or that someone is going to issue a credit card chargeback. You only want to give conditional releases when you accept a check or when you are receiving payment via credit card. Again, you can get that stamp at makemeconditionalstamp.com. Never, ever, ever record a satisfaction of lien for a credit card payment or waiting for a check to clear. You cannot make a recorded lien satisfaction conditional. There is no such thing. When you hand the clerk the lien, they're going to record it. Now that is the lien of record in the public records. Someone wants to pay you and they say, well, let me pay you with a credit card and then you can satisfy the lien. Well, what happens if you satisfy the lien and then they put a chargeback on the credit card 30 days from now, or they put a stop payment on the check 20 days from now? So you want to tell people that, hey, I will satisfy the lien, but I need certified funds, and the best certified funds are a wire transfer. A wire transfer is instantaneous, you know what happens. So in our practice, we routinely record liens and satisfy liens all the time. And the only process that we will accept to give someone a conditional release, to give someone a satisfaction of lien immediately is if they wire funds to our trust account. That's the only way we know that the funds are good. Also know that if someone prevails on a credit card chargeback, you can still sue them. You may not want to sue them, but you can. The fact that someone prevailed on a credit card chargeback doesn't mean legally that they don't owe you the money. So we do have cases in our office where someone sold construction materials or services, the end user disputed it with their credit card and prevailed, and then we proceeded to sue them in court and ultimately won. So again, the fact that you lose a chargeback doesn't mean that you have to stop there. You can sue them if you want in court. And if you have enough evidence and you did the work, you probably will win that case. So with that, we are done. Do we have any questions?
Well, thank you so much, Alex. That was great information. I appreciate it. We do have a question that has come through. So it says, can a customer force you to provide an unconditional release?
No, they cannot. And the reason, well, let me back up. Let me be more clear. There is a specific line in the lien statutes in 713.20 that says anytime anyone is presenting you funds via check, you are allowed to make that release conditional. So whoever asked me this question, if you want to send me an email, I'm happy to, point exactly in the statute where it says that, so that whoever's asking you this, you can tell them, hey, I don't have to because the statute says so. So that's my first answer, is that if someone is trying to force you to accept or to sign a release and not make it conditional, you can point them to that statute, number one. Number two, and the reason I paused, is that many times as a subcontractor, you may be signing contracts, and that contract has the process for you to be entitled to be paid. And that process says you have to sign a release either that I deem acceptable or, more common, is attached as an exhibit to this agreement. When we negotiate contracts, when we review and negotiate contracts for clients, one of the most important changes we make to that contract is we say all releases that we present, we are entitled to make them conditioned on payment. So we put that specifically in the agreement so as to avoid an argument in the future that, hey, you agreed to give me this unconditional release. Look, it says that in your contract, and that's why we want to change that language in the contract. Any other questions, Jesse?
Yeah, so another question that came through, it says, so what if a customer pays via credit card and does a chargeback or a bad check? And is there any additional way we can protect ourselves besides that conditional release?
I mean, I don't mean this as a joke. Don't take checks or credit cards. But
Yeah.
no, if you've decided to accept the payment that way, then you're stuck. You always run the risk that someone could give you a bad check or do a chargeback procedure. So no, unfortunately, no. There's nothing else you can do to protect yourself. Again, other than the things we talked about, which is to follow the procedures from the credit card processor on processing credit cards, having good terms and conditions, and then collecting the necessary information on the check if you wanted to prosecute someone criminally, and then you can send the letter for civil penalties if you want. But no, that's always the risk that you run when you accept checks and credit cards.
Okay. And then another question that came through, it says, how much does a bad check have to be in order to be considered a felony? I know you mentioned this earlier in your presentation.
$150.
Yeah, so it's not much for it to be considered that felony. That is all the questions that I have seen come through so far. If anyone does think of a question that hasn't been addressed, please feel free to reach out to us. We'll be sure to answer any questions. All right, so who is ready to win a gift? We are testing your knowledge today. I know we've asked these questions in the past. You guys should be able to answer them. If you see that you know the answer, please chime in our chat and we'll send you over a little gift from us. I know that I see somebody has already chimed in, so love to see that. Go ahead and go to the next slide for me, please. All right, so here are some of SunRay's resources to help you guys stay organized, know your deadlines, and secure your lien rights. Go ahead and scan that QR code to access these incredible resources. There's deadline calculator, project information sheets, nearby, you can check nearby states and see what their lien laws are. Remember, each state has their own set of lien laws and documents, deadlines, everything else. So check it out, see what you are required to do in those states. If you could go to the next slide for me. All right, so Alex's next webinars are going to be November 14th. Don't sign that release unless it says this one thing. And then December 12th, I recorded my lien, how do I get paid? Go ahead and sign up for free at sunraynotice.com/education. We'd love to see you guys there. All right. If you are in the Tampa area, Alex is presenting alongside with Ariella for a live seminar on October 24th. That's going to be how to get paid faster with liens, bonds, and contracts. If you're interested, register at sunraynotice.com/seminar. We would absolutely love to be able to see you guys there and touch base. All right, if you don't mind, give us a review, scan that QR code. It takes about a minute of your time, but it helps other contractors like yourselves. It also helps us get that feedback from these webinars and learn how we can better assist you. So we'd appreciate that. And then that is all we have for you guys today. Thank you so much for everybody who attended. We hope to see you guys at our next webinar. Alex, as always, you are incredible. We really do appreciate you. I hope you all have a beautiful and wonderful sunny day. Thanks again, everyone.